friends. So good to have you along. Happy Monday. It is Thanksgiving is now in the rear view mirror, unfortunately. Hopefully you're enjoying your leftovers and that they don't go away too fast. I just love Thanksgiving. It was so super fun. Hey, we got a lot to talk about today. We are talking about estate planning here on the Word on Wealth, and in our second half hour of the show, because we're going to be going right to the top of the hour, we're going to have Rich Mathurin from GQ Law. He's going to be coming in today as a special guest, talking about things that sometimes we don't want to admit that we have, and that is tax problems. So, we're coming up on the end of the year. We got about one more month. So if you're, self-employed, you're paying your estimated taxes. And if not, probably should get on that. But Rich is going to be in here talking to us about what if a tax return were not filed on time? What if it were not paid on time? What if you owe a huge balance due? And this doesn't have to apply to you. This is going to apply to anybody, business, individual. We're going to talk about how to resolve some of these pesky tax problems, because they'll just haunt you. They will follow you along. The IRS is the largest, most powerful collection agency on the planet. They employ over 186,000 people. They have a huge budget. They collect about $15 trillion in taxes every year, which are all the revenues that we have. It's one of two organizations in the United States that make money. Government agencies that make money. Number one, DEA, not necessarily in this order. And the only other one is the Internal Revenue Service. So Internal Revenue Service, collection agency for our U.S. Treasury, and the DEA, for obvious reasons, they make money because they confiscate drug enforcement agency, crime people, and collect the money out of their goods that they have hidden away. So IRS, DEA, there you go. We're going to be talking about the IRS today in the second hour. If you want to ask me a question, now is your chance. 888-344-1170, 888-344-1170. Today on the menu is lost beneficiaries. We are left, after someone dies, we are left with dealing with the residual, what's going on. It is not a day goes by in my office when I don't talk to someone about having a deceased relative. The challenge that we find is that when one of your relatives passes away, a parent, a spouse, typically parents, the most common, obviously, there's a lot left to do. And what you don't realize is how much work there is to do to literally take over someone's financial life, figure out where they were going with things, what they were doing with things, where things are supposed to go, where things are unknown, hidden, done electronically, mail hasn't got to you, change of address wasn't put in. There are 100 things that go wrong after someone passes away. And we are bent on this show to help you get through that process. If it's done right, if it's done, the best you can do, then the family pieces stay together. If it's done in a wreck and it takes too long, if you don't know what you're doing, then you could have beneficiaries that are upset. You can have the successor trustee that's upset. You can have creditors upset. And we don't want that. We want to make the transition of assets from the deceased person to the survivors. And we want to do that as flawlessly and as smoothly as possible. And hate to break this to you, there is no smooth way. We do it as smoothly as possible. Because think about that. When a person passes away, they had their income and their expenses. Sometimes they had debt. They have insurance on their car, on their home. They might have investments, a retirement account. They have taxes, tax returns, maybe tax situations. Maybe they've got life insurance. So you got to figure all that stuff out. And when someone passes away, just think if it were your life, everything that you do on a daily basis to manage your own finances, and now double that. You become the successor trustee of your dad. And now all of a sudden you literally have twice as much stuff to do, because if you're the one that's handling the finances in your family, now you're the successor trustee for your father. You're now handling his finances. And it may be short term, but it's not fun. It's very difficult. It takes a long time. And the best, you just my goal is to help you get through it so that the family pieces can stay intact. Because when someone passes away, beneficiaries want their money. Totally understandable. Were they counting on it? Probably. Did they know mom and dad had money? Maybe, maybe not. But it doesn't really matter, because now that the death has occurred, now that's the date that we start to figure out, okay, who is now entitled, legally entitled to that money. And that's what we sort out. Sometimes it's not as easy as you think. And that's what we're going to be talking about on this show. If you have questions for me, if you are a beneficiary and you're wondering when you're going to get your inheritance, if you're a successor trustee doing the best you can to try to get the inheritances distributed to your siblings or to the other beneficiaries, give us a call, listen to the show. That's what we're working through on this show, so that we can get you to the point where you're a good successor trustee, successful successor trustee, and your beneficiary that gets the benefit of the estate that your parents have left you. 888-344-1170 is the number here to call on the show to ask me questions live. 888-344-1170. I can also help you in person, offline. My number is 855-500-TRUST. That's what we do. It's what we love to do. Help you guys figure out where the inheritances are, where they're supposed to go, what's the tax issue, how to avoid it, how do we deal with Prop 19, Prop 58, Prop 13, all those things to do with death. Okay. What if, this is an interesting question. What if you can't find a beneficiary? Okay, so your job is you're the successor trustee. You read through the trust and you go, wow, dad told me I was going to be the successor trustee. I'm so happy. I'm carrying out dad's wishes. And then you go to notify a beneficiary that's named in that trust. And you look at it and go, who is Josie Brown? And coming to find out, it's somebody that used to work for your dad at a place that he owned. He and she did some of the housekeeping, did a fantastic job. And he wants to make sure that she gets her hands on the ruby ring that he had been keeping. It's from, way back when, but he wanted to make sure to leave something for this housekeeper. And so he names her. How do you find her? That's a great question. Are you required to find her? Yes, you are, because you're, as successor trustee, you read the document. The document says, give the ruby, gold and ruby ring to Susie Johnson. Okay. You got to find Susie Johnson. And if that's all it says, Susie Johnson, how do you find them? Because you can't finish your job as successor trustee unless everybody that's in the trust is treated fairly and they get their stuff. So in this particular case, this is actually a real case, different names, obviously, but we were trying to find who this person was. The successor trustee didn't know. So she started asking around, like, does anybody know who this Susie Johnson is? How are we going to get this money to her? And basically somebody figured out, hey, I think she used to work for the guy. So we hired a private investigator. They found that she used to work at a motel. They asked the motel, does she work there now? No, she moved to Kentucky. So then we went to Kentucky. The private investigator found out where she lived, contacted her. And then we took over and said, hey, you're the beneficiary of this particular person. He wants you to have this ruby ring. And her response was, who? And we ended up figuring out, she says, oh, him. Yes, I was his housekeeper and I helped him with his rentals and all that stuff. I guess he liked the work that I did. And we said, well, the ring is yours. Do you want it? And she said, nope, I want the cash. So we ended up selling it, converting it to cash. Fun things that you do with trust administration. More coming up here on The Word on Wealth with Gary Quackenbush. If you want some help, give me a call at 855-500-TRUST. We'll be back.
You don't need to know everything. You just
stuff.
need to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, we've talked a long time about estate administration. So what is that and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. So have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Tell a friend about this broadcast outreach, The Word on Well, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, GQLaw.com.
You're live. All right. Thank you for being along here on The Word on Wealth. This is attorney Gary Quackenbush. We are talking today about estate administration, estate planning, and things like that. If you have a living trust, that's fantastic. If you don't, get one. If you have a will, that's great, but get a trust. When does somebody need a trust? Short answer, if you own a home or any real property in the state of California that is worth over $65,000, it will go through probate. So if you have a house or real property, get a trust. Number two, if you want to make it so that distributions go to children not immediately at your death, but sometime after. For example, based on age. You pass away, you've got an 18-year-old beneficiary, they stand to inherit half of your stuff. It's probably not a good idea to give that to an 18-year-old. So you do a trust. And the trust says, when I die, if I have a kid that's under 25, hang on to their money. You can pay for their education. You can pay for their necessities. You can give them some earnings, give them an allowance, but until they're 25, they don't get their share. And at 25, give them half of it. And 30, they give them the balance. So you can do things like that in a trust, which is super cool. All right. I think the one thing is that you're trying to figure out if a beneficiary is financially responsible. And quite frankly, you're guessing. When you do the trust, your kids are, in the condition that they're in. If they're in good stead and they're all financially responsible and you figure it's going to continue that way, then just give the distributions to them outright after you pass away. If they're young then do distributions that are staged to go out based on ages or behaviors. If you have some kids that are really struggling financially, emotionally, they just aren't financially responsible. Why would you give them, a huge amount of money that you've worked on for your whole entire life to put together? Why would you give it to them and have them waste it? I mean, if they do waste it, they're going to be out of money. And that's really sad because now they don't have any money and any help because they wasted it all. And I don't think that's kind of an expensive lesson. So have your trustee control that, how much money they get. Those are all easy to do. Part of trust administration, part of drafting that trust is to put together the trust so that it does what you want it to do. And you're trying to control money going out to, less like financially, I just call them financially immature beneficiaries, and make sure that they're only getting money if they're financially mature, know how to do it. I mean, you don't want it to be wasted. You make sure that they are financially responsible, and you can do that with a trust. Some questions that came up that I thought I would answer because I get them a lot, and I thought, well, I should answer these on the radio show. That might be really helpful because some people are listening and want to know these things, and that's why they're asking them. What if a house has a mortgage on it? Is the question. Who pays the mortgage? So the thing that happens with a mortgage is, remember that the loan on that house is owed by, let's just say, dad. So dad owes that money. He's the one that signed the contract, and he made an agreement that if he did not pay that the house could be sold to pay the mortgage. That's what the trust deed thing is. All right. So if he dies and there's still a mortgage on the house, that lender gets paid, or they can foreclose, take the house, sell it, pay themselves, and give you the difference. Well, a foreclosure sale is not going to be a premium sale. So that's a very expensive, money-losing proposition. So if it has a mortgage on it, you just have to recognize it's got to be paid. A very common scenario is you have mom and dad have both died. They have a home worth, let's say, $1.5 million in San Diego, and there's a $400,000 mortgage on that house. That's not a big deal, right? $400,000, $1.5 million property. And one of the kids says, I'm going to buy that house from my siblings. Well, what other money is available in the trust? If there's nothing else but a house, that sibling now needs to be able to pay off her two siblings, which would be 2/3 of the value of the property, which would be $1 million. But they've also got to pay the mortgage. So of that $1 million, 400,000 would go to pay the mortgage, and then the balance would go to pay off the siblings. So you balance it all out, but you've got to work with the lender. So the challenge is, you don't own the house, neither do your siblings. So the three of you don't own it. It's owned by the trust. The mortgage is owed, the loan is owed by your deceased father. So that means his estate needs to pay that loan. So you go to a lender and say, hey, I want to borrow $400,000 against this house. The lender says you don't own the house. So you have to get these short-term bridge loans. And we have our guy, John Burrows, is on with us. He's on my show on Wednesdays, and we talk about these things. But the loan has to be, it's a loan against your potential inheritance. So we provide the trust documents and all that kind of stuff. And it gets pretty complicated. It is possible. John does them. He's an expert. We're going to be talking about that on this very show on Wednesday with John. So you got to finance it and put a lien on a house that you don't own. So that's why the lenders charge you a lot of money for loans like that. So sometimes paying off a mortgage by buying the house from your siblings can be an expensive proposition. You just have to be patient. It is possible. It's not like a regular old conventional loan. It's expensive, and it's a little bit of process takes some patience. And we're going to do fair market value. So we're going to get an appraisal, figure out what the property's worth, because we don't want your siblings later coming back and going, really, the house is worth 1.8 and you paid 1.5 for it. So we don't want that. But the mortgage has to be paid. Got to figure that out. Most kids decide, let's just sell the house, pay the mortgage, and then we will take the proceeds and we can go buy our own house, right? Because dollar for dollar, what's the big difference? It's going to be the same. You may be thinking you're getting a great deal from your siblings, but if they work it right, it's going to be the same deal as if you'd sold it on the open market and given them their cash. It can be the same thing. Unless they really, really like you and say, yeah, we want you to have a better deal than us. But it usually doesn't happen. It balances out. All right. What if a young beneficiary inherits the house? This is something that we see enough to where it is worth discussing. And that is, a parent would say, well, when we die, if our kids are little, we don't want to uproot them. So we want the house to stay in the trust for our kids to live here, so they don't have to change schools and they don't have to change their friends, and they all be well and good. So then my question is, if when you die, your kids are young and you want them to stay in the house to keep their same friends and their schools and all that, I understand. Who's going to take care of them? Oh, my sister and brother-in-law. I've talked to them already. They said they'd be happy to be the guardian of our children. And, it'll work out fine because they've got 2 kids of their own and they can take care of my kids and they love them, and their auntie and uncle are just really dear to them. So that would be great. My next question is, okay, so your kids will own a house and you want them to live in that house, but your sister and brother-in-law are going to be raising the children. So you expect your sister and brother-in-law to move from their home into your home that your children now just inherited so that they can raise your children? That will never happen, because they're not going to do it. They have their own children, their own family, right? Their own house, their own established, whether it's a rental or not, doesn't really matter. They have established their own friends and neighborhood and all that. So it usually doesn't work out. But when you start to think through that, realize that if you pass away, it's really not a great idea to keep your kids at the house, because mom and dad aren't there anymore. Things have changed and kids are very adaptable. So you want your children to go to their new place and enjoy the new family, and you get welcomed into a new home. That's the way I see that it is the most beneficial. And some of you would disagree and say, no, Gary, I want my kids to live in my house because I don't want them to have to change schools. Well, the best of all things would be for you to just stay alive, and you can make sure that happens. But we're trying to deal with plan B and plan C and plan D. Plan A is you're here to raise your kids until they're old and you're super old. Okay. Plan B is we have to figure out how to get your kids raised without you here. That for most parents is an agonizingly impossible decision, because how do you get your head around that? Okay, let's pretend like we're not here and somebody else is raising my kids. It's just hard to go there. So we do the best we can. Set up a will to designate guardians, and then the family home. It isn't really the family home. Once you pass away, the kids are going to go to wherever the guardians are. That makes it so that the guardians are not going to be financially strapped. Your kids have money in trust because you put it in trust, not in a will, and the money's available to help your guardians take care of those children. It works out really, really well. Again, that's plan B and C, not plan A. All right. What if you inherited a house and you don't want it? Maybe you know the answer. If you do, call me and tell me. I know the answer. If you want to ask me a question, by the way, 888-344-1170, 888-344-1170. What if you inherit a house and you don't want it? So that would be, the trust says, when I die, my child gets the house at 92041 Lemon Avenue. And the kid says, I don't want the house. It was my parents' house and I lived there with them, but it's not my family home. I've got my own family home. I don't want the house. What are the options? Well, it seems pretty obvious, but can you sell it? And the answer is sure. The successor trustee will likely be the one selling the property, because if the beneficiary says, I don't want that house, I know it says that the house on Lemon Avenue is supposed to go to me, but I don't want it. So they could just tell the successor trustee, sell it for me. And the successor trustee can do it. They're going to get paid as part of their job to sell the house. And it's easier for them to sell the house and then just hand you the money. It's way easier. But it's like, if you could also just take the deed, the successor trustee could say, heck no, I'm not going to sell the property. I'm just going to hand it to you. And so they hand you the deed. Now you own the property. You can do whatever you want with it. You can sell it the day after you get it, or be selling it while you're being handed the deed. It doesn't really matter, because either way, you don't have to keep the property. There's no requirement. If the property taxes go up or down, you don't really care, because you're not the owner of that property anymore. So that's a good question. The question somebody else asks is, will you have to pay tax? And the answer is, it depends on if the house is worth more than $12 million. And if it's not worth more than $12 million, there's no inheritance tax on, anything less than $12 million. Most of us don't inherit more than $12 million. Sorry, just FYI. Most of us inherit much less than that. So we don't have to worry about that until 2026. Okay. So in 2026, which is in a few years from now, then we got to start worrying about estates that are worth less or more than $6.5 million. But for right now, we're trying to make sure that we know what happens with houses that are over $12 million. So we don't have that problem for most of us. There you go. So that's what happens with a house. You don't have to inherit it. You can take the cash. All right, a couple of things I want to talk about is coming up next. We got Rich Mathurin from GQ Law coming up. Have you ever wondered, what if you don't file a tax return? What happens? We're going to ask Rich coming up. Next thing we're going to ask Rich is, what happens if the IRS files a lien against you and now it shows up on your credit report and you're getting letters from people saying, hey, there's a lien against your property. Is that going to destroy you? Is there something that you can do to take care of that? If there's a lien on your house, can you get financing? Like, can you go and borrow money against your property if there's a federal tax lien? These things are going to be talking to Rich about coming up next here on the Word on Wealth. If you want help from us for any of this type of thing, you can call 855-500-TRUST. That's 855-500-TRUST. Coming up next, Rich Mathurin from GQ Law.
You've got questions. We've got answers. You don't need to know everything. You just need to know where to find answers you can.
Quick question.
Well, with Gary Quackenbush. Blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com. 855-500.
You're live.
Hey, everybody. Welcome to the show. This is Gary Quackenbush. I told you we'd have our guest today, and that was going to be Rich Mathurin from GQ Law. This is where we're going to talk about taxes. It's not tax time yet, but every day is tax day here at GQ Law. So I got Rich on the show with us today. If you're watching this on YouTube, you can see Rich. And if you are listening to this on the air, you can go back to our YouTube channel at GQ Law, and you can find this particular show where we're talking about, and we just, because we want to find out I mean, everybody's got tax issues. Everybody hates to pay taxes. I don't know. Rich, do you like to pay taxes?
Not particularly.
I don't want to pay taxes at all. I know that's what you got to pay for a whatever they say for a civilized. It's the price we pay for a civilized society, but we want to pay as little as possible. So that's what we're doing. So I wanted to ask Rich some questions specifically, just to kind of get an idea. First of all, Rich, welcome to the show.
Great to be here.
Sorry, I jumped right in. Rich is a tax attorney. He has been an attorney for, is it what, 15, 17 years now? How long have you been a lawyer?
I got my license in 1999. So
Rich
20
has been an attorney for a very long time. So that's 23 years.
Yeah.
Dang. So between the two of us, we've got 50 years of experience here. 56. Wow, Rich.
Getting old.
I know. We should know everything. So if you want to ask us a question, call us at 888-344-1170, 888-344-1170. So the first thing I wanted to know, Rich, is, some people just, they make money. I think the classic is you're self-employed and you're making money, and you used to be a W-2 employee and now you're working on your own, deciding to throw the hammer yourself or whatever you're doing. You're making money. You're being paid as a consultant. And you're like an independent contractor. So you're getting paid at the end of the year. You get a 1099. You kind of rough out your tax return and go, oh my gosh, I have to pay $8,000. What happened? Didn't anybody withhold any money from my pay? So I want you to address that a little bit. But the main thing is, what if that person said, oh my gosh, I'm not going to file these tax returns. Forget it. I can't afford my $8,000 in tax that they rough out. What if they don't file a tax return? Is the IRS even going to know? Is the state going to even care? How does that process work?
Yes, they would know. They would get the copies of the 1099s that the people that you worked for filed with the IRS and deducting the payments to you. And I would think that they would typically what they're gonna do is create what's called a substitute for return, where they would take the 1099 information that they have and use that as your basis for your income, then give you a standard deduction and then tax you at the highest rate available. And then those taxes, it's usually much higher than if you had done it yourself. Secondly, those taxes would not be dischargeable in a bankruptcy.
So let me get to that. So I want to make it really clear. So I'm just kind of reiterating. So the IRS, if you make money, I mean, somebody pays you money. If it's wages, they give you a W-2. If you're an independent contractor, you're not getting wages. The person that pays you actually sends a report to the IRS. So when they send you the 1099 saying, okay, this guy made $5,000 in consulting, they send that information also to the IRS.
Yes, they're deducting it off of their business tax return, also a personal tax return. So they want to take the deduction,
okay.
But they want you to reflect that as income on your return.
So the IRS already knows that, and that's what we're talking about. The IRS goes in and they create kind of a dummy return, and they have your income information. So they put that on a tax return. Well, what if I'm married? Does the IRS not put me as married filing joint?
No, they would assess you as a single individual. Like I said, they would take they give you the standard deduction for just a single individual, and then they would tax you at the highest rate, the single rate tax return. If you don't file, they're going to just take all the liberties they can.
Because so it's like the IRS isn't required to do a proper tax return and call you and say, hey, you didn't file your tax return, Rich, and so I want to know. Yeah, in fact, I've even seen where if they see that in the past you've filed married filing joint, they know that there's somewhere a marital status. And then now if they do the return for you, they're going to say married filing separate, which is like the highest bracket. And then they just tag you with that. There's no withholding because it's self-employment income. And then I guess once they do that, so it's kind of this dummy return that we're talking, we call it a substitute for return. So how do they notify you along the way? Is it just all of a sudden surprise, you owe money, or what happens?
No, they're going to send you a series of notices. I think you had said every 5 weeks they come out, kind of, hey, you owe this money. Hey, you owe this money. Then eventually they're going to give you a 90-day notice. And then eventually they're going to give you a 30-day notice before they take their involuntary collection activities.
So that, and then so if the IRS, so I don't file my return, and maybe I do it for multiple years. The IRS then goes and files my return for, 2020. I think we're seeing 2020, 2019, 2018. They file the returns for me. They come up with a number. They start sending me letters saying, hey, you owe money. For them to take money out of my bank account or to go to my employer or even to go to wherever I'm getting paid, do they have to go to court to get a judgment, or how does that work?
No, they're the most powerful collection agency in the world because they don't need a judge's order to levy your bank account or say that you owe the money. Like a credit card company would have to go and file suit against you, get a judgment, and then file a judgment lien against you, and they may or may not be able to collect on that judgment lien. Whereas the IRS automatically, they get both collection rights to levy bank accounts, garnish wages, and file liens.
So it's just interesting. I think some people, and I think this is probably part of your experience too, is that some people really believe that, well, let the IRS come after me. They're going to have to get a judgment. Because if you don't pay your credit cards, it wrecks your credit and all that kind of thing. But it's like if the credit card company is going to involuntarily, like actually take your wages or take your bank account, then they're going to have to go to a judge, and that takes forever. With the IRS, instead, it's just administrative.
Yeah, and they assess immediate penalties and interest. I think a lot of people are shocked by those amounts too. Where did all the sometimes the penalties and interest can be more than the tax, or the same as the taxes owed, can double the amount that you owe. So it's better to deal with it. I have seen in our cases, a couple recently where they had filed substitute for returns, and our tax preparer fixed both of them, and the IRS said that they owed a lot of money, and they ended up that when we fixed them that they actually were due refunds. So it's it's important that you do file your own returns and make sure you get all the deductions and get your tax rate assessed properly.
All right. Hey, it looks like we got a caller from El Cajon. Hey, this is Gary Quackenbush and Rich Mathurin. Welcome to the show. Dan from El Cajon. This is Gary Quackenbush. How you doing? Hey, Dan, can you hear us? We are having technical. Hey, Dan, this is Gary from the Word on Wealth. How you doing?
All right, I'll try and talk to him.
All right, so that we're gonna get Dan. Hopefully, we can get Dan back on the line here. So, okay, so with the IRS then taking the money, they don't need a judgment. They come after your bank account. Do they? So, let's say then you do the tax return that corrects liability. So let's say the IRS then things you move. How many people do you have come in here that say, oh, "Gosh, I didn't know I owed this money. They took my bank account. They've stolen my money, and I didn't know." How many people tell you that?
Well, they don't have they do not have a duty to find you if you moved and you haven't told them either through a change of address or your latest tax return notifying them that you moved. Then they don't have a affirmative duty to find you. You have to, they can keep sending the notices to the wrong address, and then if you don't respond, they can still levy you and lien you, and so that's again a special power that they have.
So it's interesting because it's like they don't have to personally serve you. So it is, it's not uncommon to have somebody come in and say, the IRS stole my bank account. And sometimes you don't know whether it's the IRS or the state of California, but yeah, they can take your bank account. So you're saying though, if they took your bank account and then it was based on them filing like substitute returns or dummy returns, you can go and correct the tax returns and maybe show that the amount of money they just took out of your bank, it really wasn't even owed because you didn't owe any taxes. Is it possible to then get that money back?
Yes, if you filed your own return and it showed that you were due a refund, or you were, the tax balance was less than they had said you owed, then you would be due a refund. Yes.
That's so great. So the bottom line, what Rich is telling us is that there are solutions to tax problems. If you haven't filed tax returns, you're probably up at night trying to think about, oh my gosh, when's the IRS going to come knocking? Well, they will eventually. Get your tax returns filed. That's something that can be straightened out. You actually have a constitutional right to file your own tax returns. So even if the IRS did it for you, even if they're taking your bank account, even if they're levying you, you can still do a corrected tax return. There's different ways of doing that, but it's possible to correct it so that the correct amount of money is being collected. The next thing I want to talk about with Rich is, what if you cannot afford to pay the taxes, whether the IRS assessed for you or whether you filed returns and couldn't pay? I mean, are there options, or is it like, man, we're just dead in the water? We're going to talk about that coming up next on the Word on Wealth. Give us a call at 888-344-1170.
You've got questions.
Yeah, not sure what happened there. He was on the phone, just I guess was multitasking.
Q Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. G.com.
Your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do auto reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQLaw.com. 855-500-TRUST. GQLaw.com.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
All right. So good to have you along, friends. This is Gary Quackenbush and Rich Mathurin of GQ Law. We've got Rich here in studio today, right up to the top of the hour. If you got questions for Rich Mathurin from GQ Law, give us a call at 888-344-1170, 888-344-1170. So Rich, we've talked about the IRS deciding to create returns for you, come up with a number, and then go and take the bank account. It's like, wow, that's crazy. But take bank accounts, go after wages, file federal tax liens. What are some, so let's talk about a scenario where they took the bank account and you go, luckily, there's only $300 in the bank. It's still a lot of money, but at least there wasn't like just recently deposited paycheck. And then they filed a federal tax lien. And now next thing you know, we're getting notification that next thing is the employer is going to be contacted. How do you stop this? It just seems so like stressful for people. What do we do?
Well, generally, first of all, I will say that the IRS does generally want to be paid in full. So if you do have the ability to pay in full, based on what your balances are, you have some number of months to pay back, and you would get into a payment plan with them. If if you can't full pay, then there is possibly a partial pay installment agreement where you pay some, but not all of your balance, and some of it would fall off under the statute of limitations. That would be based on your income and assets. If you're
So
really,
the IRS has a statute of limitations also. Can
yeah,
you talk
it's
about
10,
that.
10 years from when the tax was assessed. So
Okay.
if it was, you filed in you 17, filed in 18, and let's say April 15th, 2018, then if you had no tolling events, anything that stopped the statute from running, your balance would fall off in April 15th, 2028. So they have 10 years to collect. But if you file a bankruptcy, file an offer in compromise or anything like that, it does toll or stop the statute while you're in those particular programs.
Okay, interesting. All right. So it just seems like, yeah, the collection delay would seem like a good idea to stop them, because if they're coming after your wages or coming after your bank account, then we got to do something to stop them. So if we did a determination of them not being collectible, like prove to the IRS, like we basically show with financials, like they just don't have the money to pay. The IRS sometimes will back off.
Yeah, that's probably the best scenario, because the collections stop, the statute continues to run, and you obviously don't pay anything while you're in non-collectible. But one thing to keep in mind with non-collectible, it's just at a point in time. If the next day you win the lottery or you get a job and you become gainfully employed, they would put you back into collections, and you would have to set up some type of a payment plan going forward. Another
Okay.
thing that I will mention, if you cannot full pay under their installment agreement, you could do what's called an offer in compromise.
Okay,
That's
I like
where
those.
that's sort of a formula-based system where you're offering 80% of your assets and your net income times 12. It's kind of a complicated formula, but as long as that number is something that the IRS would consider. But if you have equity in your home or retirement accounts, things like that, those would have to be included. So people
Okay.
with high incomes or lots of assets are probably not good offer candidates.
Okay. So the idea of the offer is it's like going to the IRS and saying, hey, I owe you $50,000. Here's $5,000. Let's make a deal. And that $5,000 has to be like all you could afford to pay. So if you've got, $500,000 of equity in your home, the IRS is going to look at your $5,000 offer and go like, no, you got equity in your home, go finance your home or whatever.
Yeah, I think it's misleading. A lot of people, saying out there that you can settle it for 5 cents on the dollar or whatever, pennies on the dollar type of thing. Maybe that's, there are 100, like you always say, 100 pennies in a dollar type of thing. But,
right.
The offer is a specific thing that you do need to qualify for. So it isn't some guy in the back room chomping at a cigar that gives you a thumbs up or thumbs down. It's sort of a formula-based thing.
Wait, it's not.
That you have to, that they do their calculations, and they have their computers that churn out these things, and they have offer specialists that do this specifically. So you do need somebody to deal with them. I've had really good luck, making sure that the offer is presentable and that it makes sense, and getting it through with the clients saves huge amounts. I've settle for 5-10 cents on the dollar, sometimes like pennies on the dollar.
Oh,
literally.
Yeah. We had that one where it's like, it would be like, I don't know what it would be. It was it would be like 0.001%. I mean, it was that huge tax liability. And then because Rich was able to prove, no assets, and the guy was just really struggling, and it was, going on for a long time. And based on his age, the IRS, we got an offer that I mean, to this day, I've been doing this for 30 something years. And to this day, I've never seen anything quite that incredible. But the offer program, it's great. I'd love to see that happen to people if they qualify. The thing that bugs me, and I know you feel the same way, is the thing that bugs me is that we have people that will come in and say, I already called so-and-so and I paid him, $8,000 and they didn't do anything for me. And we go, what were you paying him for? He said, well, they said, the lady on the phone said, oh yeah, you qualify. Yeah, we can do an offer for you. We can do the money. And then they go in and pay the money. And this firm or whoever I call them is they put together the offer and compromise form. They don't even fill it out right, and they send it in. And of course, the IRS rejects it. And the next thing the client gets is this notification, and that their offer's been rejected because they can afford to pay the full balance or whatever. And then the firm says, wow, the IRS is really tough. Sorry that I guess you're not getting your pennies on a dollar deal. And then it's like they're done. But But that frustrates me because we work so stinking hard in getting all the information that we need, all the data, the past income, like looking into the future, trying to figure out if people qualify and submitting offers that really work. But I mean, to me, it seems like, I mean, that's kind of our thing, is that we want to make sure if we submit a solution, it's going to work. It's not just like, well, let's see if this sticks, but we really calculate that out. So we're talking about non-collectible, currently not collectible, installment agreements, offers and compromise. And then now let's talk about, there's another way. Talk about, is it possible, if you owe taxes to the IRS, is it possible that a bankruptcy would be a way to eliminate or reduce some of these taxes?
Yes, and in a lot of cases, a bankruptcy is a very, very powerful weapon to deal with your taxes. Like we mentioned earlier, though, those substitute returns, if you didn't file your own returns, even if you replace them later, those are not dischargeable in a bankruptcy. But there's a three-pronged rule. It's, I think, 3 years from when the tax was due, 2 years from when you actually filed, and 240 days from when it was assessed. As long as you meet those criteria, we can discharge balances. I think for a current year filing, we can discharge 18 and back. So next year, 19 and back type of thing. So if you have some back taxes that you just haven't dealt with, a bankruptcy is a very, very good option that, it wipes out the taxes. You're not personally liable for them anymore.
Now, what if, Rich, and thanks for explaining, that was a great explanation. What if somebody comes in and they just really, and this may sound funny to some of you, but it may, strike a chord. They come in, they just really don't know. They just know that they got levied. They're just not sure when was the last time they filed. They don't know how much is owed. Maybe there's a divorce in there. Maybe they've moved a lot, been unemployed, these things, but they just really don't know what's going on with their tax situation. They just know that 2 years ago, they were getting pounded by the IRS and now all is quiet. What can we do to figure out for them, like what a solution would be?
We have a great tax software where we get a power of attorney from them for the IRS, and then we can run their tax report, and that gives us all of the information, the years that when they filed or didn't file, the balances, penalties, and interest for each year, when your balances would fall off under the statute of limitation, any tolling events, when it might be dischargeable in a bankruptcy, your payment history, your wage and income for the last 10 years, your W-2 and 1099 information. So I would suggest that report.
Wow.
That tells you a lot. That gives us, like you mentioned earlier, pushing people into an offer and compromise or a bankruptcy, and then finding out that, hey, the offer just isn't going to fly, or bankruptcy, you aren't able to discharge the taxes you want to discharge. Run that report for us. Let us find out exactly what the heck is going on with your situation. Then we can best, advise you whether, hey, you're probably going to have to go into an installment agreement. Maybe we can do a partial pay installment agreement. Maybe offer is the best solution for you, or maybe bankruptcy. You really get a lot of bang for your buck with the bankruptcy. Bankruptcy filing fees and just the filing fee, and then you can discharge hundreds of thousands of taxes. That's a really good deal.
And I guess the other thing about bankruptcy is, like, we're talking about the taxes in bankruptcy, but then typically, don't you, it seems like if people have tax problems, there's some credit card debt, there's some other residual stuff, and the bankruptcy will deal with that stuff as well, right?
Yeah. Credit cards, medical debt. The two things that aren't dischargeable are alimony and child support, and student loans. So maybe the student loans it seems like there's some push to get those to be dischargeable, but right now they aren't. And one thing that I will mention also is a huge change to the bankruptcy laws back in January of 2021. They moved the exemption for how your equity in your residence. It has to be a residence, but it used to be like 75,000 for an individual, 100 for a family. Now it's like in San Diego and Orange County and LA County, it's like 600,000 I can exempt in equity in your home. So you can stay in your home and still file bankruptcy and discharge all the other debts.
That's pretty incredible. And I mean, the reason that stuff like that happens is because it's with debts and stuff like that, the laws are set up to not throw you under the bus, but to give you a fresh start. And that's the thing with bankruptcy that I think is pretty incredible. If you have equity in your home, you preserve it. You have retirement accounts, you can preserve them and still get rid of your debts. And it may seem like a big deal. Yeah, you got $500,000 of equity in your home. That's great. So should you use that to pay off $100,000 in credit card and medical debt because you've had these problems? Well, then you got to sell your home and then you lose the cost of sale. And then you got to go buy another one. The law is set up so that you can protect your home. That's why it's called the homestead exemption. So if you want to know about any of these things, give Rich a call, 855-500-TRUST, 855-500-TRUST. Talk to him. He's an expert. What he knows what he's talking about. 855-500-TRUST. Talk tomorrow, everybody.
Thanks.
Thanks, Rich. Appreciate it, man.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its on Wealth with Gary Quackenbush is sponsored by
Thanks, Gary.
Radio
Thanks, Noah.
Network.
Talk to you tomorrow.